Okay, so for today's lecture, we're going to start with, torts, and a lot of it is civil in nature, whereas last week we talked a lot about criminal. So when we start to talk about civil litigation, I want the first thing that should pop into your mind is the burden of proof. So whenever we talk about a civil conflict, what is that burden of proof?
Preponderance of evidence.
Right, and if we were to put that on a number scale, what would that number be?
More than 50%.
More than 50%. So the cases that we talk about today, and when we talk about like the material for today, keep in mind that when one person sues another, they just have to show by preponderance of the evidence, more likely than not, that their claim, their action is correct. That's how they can win in their actual lawsuits. So today, what we're going to be talking about is, it's a couple of different topics. I know there was a lot of material on the syllabus. We actually go, it's a lot of different topics, I know, but we're going to start with intentional torts. And intentional torts, I don't spend that much time on the actual intentional torts aspect. It's about assault, battery. It falls into automobile accidents, professional malpractice, product liability, and the purpose of torts is, or intentional torts, there's three basic principles. And you don't have to write this down. This is just a listening thing. It's to compensate people who sustained the harm. And you place that cost of compensation on the person who actually did the wrongdoing. And sometimes you want to place enough monetary value that it prevents other people from making that same mistake in the future. So when somebody finds out, like, hey, if I do this, if X does this to Y, they end up having to pay $500,000, it'll make other people think twice about making that same thing. So when I gave you that definition just now of intentional torts, and I said it's, assault, battery, automobile accidents, professional malpractice, product liability, there's always 5 elements that you need to know. And this is something that you need to write down, okay? When we talk about negligence, car accidents, when we talk about product liability, when we talk about medical malpractice, when we talk about slip and fall, when we talk about legal malpractice, when we talk about other certain types of torts, product liability, there's always 5 elements, right? 5 elements that must be there in order for you to be able to recover. So this is something you must know. This is a write it down moment.
Professor, sorry if I interrupt you. I think you're so excited.
I'm still breathing. My heart is going so fast still.
I don't think people are following up whatever you're saying.
All right, I'll try to slow it down a bit. I'll slow it down. Okay, so there are 5 elements in every negligence action. And those 5 elements are, I'm going to say them first, and then we're going to explain each one. Duty. You know what? I'll actually just put it in the chat for you. How about that? Copy.
It's just you're speeding. Like, that's what I mean.
I don't even think I'm that fast, but I'll take your word for it. So you see that I put in the chat. It's duty, breach, proximate cause, actual cause, and damages. So those are the 5 elements, meaning the 5 components of every negligence action. And in order for somebody to recover in a negligence action, they have to have these 5 elements. I'm going to give you an example. I was running around. Clearly, I was running around, right? I had a meeting to go to, and after that meeting, I had to go pick up my kid from my mom. And I had to be here by 6:30, and of course, they're all different points of Staten Island. So I go to my parents' house. My parents are older. There's snow, and there's been ice. And this is actually like real life. So my parents' driveway already has their car and has my sister's car. She was there. And then, so there was no space for me to park. So I parked behind my neighbor. So they had a car and I just parked behind them. When I was trying to go into my parents' house, there was ice. I mean, you're not talking snow. It is major ice. I had to try to hover so I could make it into the house without falling. So slippery, and it's on the sidewalk. So it's not their property, it's on the sidewalk. Now there's a dip right in front of their house. So it seems like all the water or the ice accumulates right there. The neighbors, it's clear you can actually walk there without any slip and fall accidents. So now I run in, I get my kid, and now I'm coming out and I'm hurrying, and I forgot his shoes. So I'm carrying him. and it's icy and I'm about to slip. My neighbor sees me, he comes and he helps me. And you know what my neighbor says? He slipped and fell already. That it's very icy and he's aware. Now he said it jokingly, all right? I didn't see, he wasn't injured, he wasn't harmed or anything. But clearly I'm now on notice of this icy condition in front of my parents' house. I called them up. I didn't call them. I called my sister who was there because they're not going to check their phones. And I said, tell your parents that they need to clear that ice because that is a classic slip and fall condition. Once you have notice, you got to clear it up. And you're going to see that in some of the cases that we talk about. I don't know if it's today or next week, but slip and falls are very common negligence actions. So now applying that, let's say I did slip and fall, or if my neighbor slipped and fell, in order for that neighbor to have an actual lawsuit, legitimate lawsuit against my parents, there has to be 5 elements shown, the ones I sent you. Duty. When we talk about duty, and we're going to talk about it in more detail, duty is the duty one person has to another. The sidewalk in front of your house, you have a duty to clear that up. When you're driving on the roadway, you have a duty to follow the law. The duty is the relationship between two people or one person against another entity. There's different classifications of duty. Remember last week when I spoke about that example that I gave when I said, like, if you were having an allergic reaction and I was coming to like save your life and I decided not to, did I have a duty to actually help you? And I said, you're all above the age of 18. If you are minors and if I was teaching an elementary class or like junior high or kids that are under the age of 18, I, as a teacher, I have a duty to protect or to take care of young people. A hotel has a duty to maintain safe areas for their guests. So the duty is it's a relationship that exists between certain classifications of people, okay? And again, we're going to spend more time on this a little bit later. I'm just kind of trying to give you a preview here. When we talk about the second element, breach, a very simple question: was that duty breached? So in a slip and fall, the owners of the house have a duty to clear that sidewalk. Did they breach that duty by failing to do that? Did somebody fail to follow the speed limit when they got into an accident? Did they breach their duty to kind of follow the law and drive safely? Was there a breach of that duty? So that's the second question. The third and fourth is the actual cause and proximate cause. Actual cause is the actual incident itself. I'm going to start with that and then I'll do approximate cause. So actual cause is that slipping, that falling, that crash of the 2 car accidents. If we talk about a workman, like somebody on a work site, and then there's injuries happening as a result of unsafe work conditions, it's the actual accident. Proximate cause is a very interesting legal concept, which we're going to delve into a little bit later. But proximate cause is, but for that breach, would that have happened? It's called the but for condition. But for, B-U-T space for, but for this breach, would this incident have happened? And then the last thing is damages. Were there damages incurred? Even if you have the first 4 and you don't have damages, there's no lawsuit. So let's apply the scenario I just gave you about my parents and my neighbor. Do my parents have a duty to clean that sidewalk? Yes. Did they breach that duty? They did. They have not cleaned it up. Okay. Was there actual cause? Did somebody fall?
There was.
Yes. Had that person not fallen, had they done what they were supposed to do?
Yeah.
Right. Were there damages?
No.
No damages.
He was damaged to you.
Yeah, I mean, he looked fine. He helped me. He held my hand. Then I ended up leaning on top of the guy's back so I could make it to my car. He wasn't damaged. There was no injuries. Okay. Unless you have all 5, you can't sue because you need to have the 5 elements there in order to have a successful negligence action. Okay. So again, we're going to go into depth more, and you'll see more examples that are highlighted by the cases that were scheduled for today. Okay, so those are the 5 elements, and those are things, let me tell you, let me say it again, you need to know these 5 elements because they come in like we talk about a lot about them, so just make sure that you know it. The next case we're going to talk about that's on the syllabus is Philip Morris versus Williams. And that is actually a very good case, and I love that case. Can you tell me, anybody read Philip Morris versus Williams and want to share it, what they learned or what they understood?
I did actually.
Okay, go ahead. Oh, FYI, before you start, Amar, what happens is, now I don't give assignments, I don't tell people to read, right? I'm expecting that you do. And there will be times when I ask for people to tell me about the cases that are on the syllabus. If nobody knows the cases, nobody's read it, and nobody's going to volunteer, then I automatically add that to the test, and I don't tell you about it. I'm not going to go over it. So you need to read, and you need to prepare. I know some of you guys said that you had a group, study group thing. Divide up the cases if you're not going to read them all. But once it gets to that point where nobody's reading, it's going to be tested on. So just kind of keep that in mind. So Amar, you've saved them on Philip Morris. Although Philip Morris is a case that I love, so I do sometimes test about it. It's a great case. I love it. Go ahead.
Don't forget, people will hate me in this class, but because I took it and I dropped it, so I learned my lesson. So that's why people, I know how it works. So
Yeah,
sorry.
exactly. So she has to read. That's good.
Yeah. So it's about a case that a widow, she's suing the manufacturer of Marlboro company for cigarettes because her husband died because he was a heavy smoker. And they said that he was smoking heavily because he was thinking that it's okay to do so, just because like the manufacturer did not used to put any warning on the packages. So that's why she sued the company. And then the court wanted to like kind of give a lesson to others. So it's about punitive damages. So in the beginning, they granted her like 800,000, and then on top of it, if I remember right, 75 point something million dollar in punitive damages, which is above the what maybe usually the court would give. And then they appealed again. It went down to 32, and then both appealed again. And then the last court, as I understood, it made it again 79 point something,
Right.
just so it gives the lesson to manufacturers for like cigarette companies, so they don't neglect and don't send wrong messages to people to smoke or
Not smoke. Excellent. Very good. This was not an old case. Do you remember the year?
2007.
Yeah, it was a very, I mean, I think it's a very recent case. It's not old. And I will tell you, does anybody here smoke cigarettes that has a package of cigarettes on them?
Nope.
Good. Okay. Well, that's good. I'm happy actually. So usually in class, in live class, I always have somebody that has a package of cigarettes, and I always make sure to qualify smoke cigarettes because that's what I'm looking for. I will tell you also, again, from life experience, my dad growing up used to smoke like 2 packets of Marlboro a day. Like it was like the first thing he did when he woke up, cigarettes, 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 cigarettes. And with Marlboro, there used to be like a rewards program. So like you would like take the side of it and you would like collect them and you could get like stuff. He had like winter jackets. We had a canoe. We had a canoe that was sponsored by Marlboro. Now, my father hasn't smoked in, solid 20 something years, but I remember growing up, and this is like my era now, and that's the difference between, me and you guys. I remember seeing commercials for cigarettes. Camel always advertised. Marlboro, there was advertisings. That case that we just heard about is the reason on cigarette boxes you have a huge warning about the effects of nicotine, tar, and how it can kill you. This product may kill you. This product is dangerous for pregnant women. And it has that in huge, bold letters. Why? Because this woman, Miss Williams, she recovered whatever that number was, $800,000 or 82,000, whatever that number was. But that 79 million in punitive damages. What do you think punitive damages are? If you had to give me one word as a synonym for punitive, what would it be?
Punishment.
Punishment, exactly. Punitive damages are awarded as a way to punish people for wrongdoing. So Marlboro here, Philip Morris, got punished big time, but that was to send a message to all the other cigarette companies that they need to be clear about the effect that their product can have on consumers. Okay, so that is Philip Morris. Great job, very good. The next case here, also I love this case. You know what? Actually, we're not there yet. Okay. Because I have some stuff in my notes, but they're not on your syllabus, so I'm not gonna even bother talking to you guys about it. The next thing when we talk about like intentional torts is battery or assault. And when we talk about battery or assault in a civil sense, it's not the criminal aspect, right? There could be monetary damages to this. And battery is essentially, offensive bodily contact, intentional infliction of touching. And it has to be, battery has to have like this reasonable person standard. We're going to talk about the reasonable person standard again, a little bit later. But again, if we were in class, I could demonstrate this. Like I'd usually just walk up and I'd like touch somebody on their shoulder, right? Somebody like could freak out that I actually touched them, especially now with COVID. People don't want to touch or go anywhere near you, right? So now let's say if I touch somebody now, okay, and you freak out, did I commit a battery? Pre-COVID, it would not be considered a battery because the reasonable person would not find that to be offensive touching. But now, if you if you cough, if you cough and you're near somebody, they're going to look at you like you just committed the biggest crime in the world, right? So our levels of comfort and the reasonable person standard has certainly changed from a year ago to now. So that's battery. Assault is kind of like the same thing, but with assault, it could also be a mental component. If you know that somebody is deathly afraid of snakes or rats or something like that, and you put it underneath the chair so you can play a prank on them, and then they end up suffering a heart attack as a result, that's assault. Number one, you could have criminal consequences, but it could also have civil consequences as well. Let me see what else I want to talk to you about. False imprisonment, also fun concept. And false imprisonment is there's a case, but I didn't assign it, so I'm not gonna go over the details. But false imprisonment, if I prevent you, again, if we were in a physical classroom, I could demonstrate this, but I can't do that now. If we were in a classroom that only had one door, and I love teaching so much that it's like 9 o'clock, 9:30, and I'm blocking that door and I prevent you from reading because I just want to keep on teaching the wonderful world of business law. Is there any type of false imprisonment? Am I preventing you from leaving? Am I preventing you from having that freedom to leave? Could
Yeah.
be, right? What if we were on the first floor and the windows were open because it was a beautiful summer day and you could just jump out?
No,
Is there also
there is another exit, so it's
there's
not.
another exit, right? So it depends on the situation, the facts, what's actually there or not. So false imprisonment, if I prevent you and there's no way for you to leave, but if there's a way for you to leave and you just think you can't leave, that's on you. But that's a simple way to kind of explain false imprisonment. The next thing that I want to talk about is defamation. And defamation, you've probably heard this a lot, and you've probably heard libel and slander a lot. But defamation is a false communication that injures somebody's reputation. And that also has elements. I'm going to put this also in the chat. It's just easier that way. And then I'm going to talk a little bit more about it. Okay. So the elements of, and I want you to think of defamation as an umbrella, and underneath the umbrella is libel and slander, and I'm going to get to that in a second. But defamation itself needs to have these 4 elements. Again, elements, when we talk about elements, it's the components that make something what it is. So for defamation, it's false and defamatory statements concerning another. It's an unprivileged publication to a third party. It's, depending on the state, knowing or failing to ascertain the falsity of that statement, and then proof of specific harm. So let's give some examples about defamation. If I am, let's say I clicked onto Zoom early before our class actually started, but nobody was on at the time, and then I start talking to my husband about, I'm going to pick on Joseph Gallo because I remember him from the examples he gave last week, right? Didn't forget you, Joseph. And I start talking about what an awful kid Joseph is. And he, he's not this, he's not that, blah, blah, blah. And I start talking about him. At that time, there's nobody there. But let's say somebody popped up and heard this. Let's say a professor came in and listened to this. And they were like, oh, that Joseph, he's so awful. I'm going to fail him. He's doing the same things in her class as he's in my class. Can Joseph sue me for defamation? Go through the elements.
Yeah, that's what I was about to say.
Yep.
Going through the elements.
Yeah,
If
go through the
that
elements.
caused harm for him.
Was it
then
a false statement? That's the first thing. Was it a false statement?
it was.
Okay, we'll say, yeah, Joseph is going to say yes, it was a false statement because he's a great kid. Okay. Was it an unprivileged communication? If I was just talking to myself, by the way, if I'm just talking to myself, and I do that a lot, and there's actually no third party, even if it was not a false, if it was a true statement, and I'm talking to myself, there's no defamation because it's not being published to a third party. Depending on the state, failing to ascertain the falsity of a statement. I love that one. I love number 3. We are so used to now, what is that phrase? I forgot it. Fake news. Fake news, right? You hear that all the time. Fake news this, fake news that. Back in the day when I was a young person, the news was seemed a little bit more credible. It would just kind of tell you what the facts were without having to skew it one way or the other. Now, depending on the channel that you watch, you get a very different perspective of a particular event transpiring, right? So are those people who are giving us the news, can they be sued for defamation if they are failing to ascertain the falsity of a statement? I don't know. So much of it now, when you listen, and I don't recall this, maybe because I didn't have cable when I was younger, but I don't remember ever seeing people kind of just spew out whatever they wanted. Like now, it doesn't matter, again, liberal, conservative, it doesn't matter which channel. They're all just talking about whatever it is they want to talk about and their perspective. What degree do you have? What basis do you have? Are you an expert in that field? Or is it just because you have a podium and you have somebody listening to you? Does that make you an expert, right? So that's why I love number 3. And again, proof of specific harm. Go back to the first example I gave about Joseph. Did he actually fail as a result of the statements that I gave? Did he actually suffer harm? If there was no harm suffered, got nothing. So now I'm going to give you a different example, okay? If one of you guys started putting on some kind of social platform, I'm a horrible professor, I did X, Y, and Z, I don't know what I'm talking about, giving whatever it is, and you come up with all these things, and as a result, I lose my job. Was it false and defamatory? Still, you go through the elements: false and defamatory, unprivileged publication to a third party. Did you fail to ascertain? Did I suffer specific harm? If there was no harm suffered, Nothing. But if I lost my job as a result of what you just did, then I can come after you for defamation. Now, you've heard the words before, libel and slander. What's the difference between them?
Written and oral.
Right. Somebody just asked, does the harm have to be physical damage? There has to be a loss of something. So I'm not being physical. Like, you mean like, am I being beat up, or like, can you give me a little more?
So going back to the example of failing Joseph, that
Yes.
will count as harm since he's lost something, correct?
Yeah, him failing a class would count as harm.
Okay, so it doesn't have to be physical. It can also be emotional or
Correct. Yeah.
financial. Okay.
Financial, absolutely. Financial is actually the best one, because that's how you really show specific harm. That's how you're calculating the recovery when you're suing somebody based on that specific harm. And I'm going to just go back to libel and slander for a moment. So libel is, this one I want you to know. I want you to know the difference between libel and slander. So libel has to be written, printed, it could be TV, it could be radio. And slander is spoken, more oral. So for libel, written, printed, slander, spoken. So when people say, I'm going to sue you for libel, I'm going to sue you for slander, do they actually know what the difference is, or are they just, whatever? But now you know. So again, libel is written or printed, and slander is spoken or oral. What if you were speaking it on the radio? Then it's mostly the libel, not so much the slander. You have to have that not news, but like that way to kind of transmit the information. Okay. So next, next this is another thing like for intentional torts, and it's appropriation. And appropriation, the case actually we're going to talk about really highlights the appropriation. It's the unauthorized use of another person's name or likeness for benefit. So who can tell me about White versus Samsung? Also, I love that case.
I can say if they don't.
No, Amar, wait. Anybody else? White versus Samsung.
I can go for it.
Go ahead.
So White versus Samsung Electronics was a case in 1992. It occurred when the plaintiff, Canna White, a hostess of the Wheel of Fortune, she noticed an advertisement billboard that depicted a robot in her likeness, and it noticed that the robot had wigs, jewelry, dress, and it was in a stance and a pose that she was known for. Wait, let me look at my notes. Was the quote longest running game show 2012 AD. Now, at that time, White didn't consent or receive any kind of payment or royalty from the ad, and she wanted to sue Samsung for it.
Very good. I muted myself because I know my kids were in the background. Very good. Yeah. Do you guys know who Vanna White is or no?
Yeah.
When I see people shaking their heads no, I was like, oh man, Vanna White, guys, Wheel of Fortune. That show has been around forever. She looks exactly the same now as she did like 50 years ago. That's the wonders of plastic surgery. But yeah, she sued Samsung. Why? Because they appropriated her likeness. She is a famous person. Okay, to possibly put it liken it to a figure that young people, Snooki. Does that sound familiar or no? Do I have to even bring it more? Okay, you're nodding at Snooki and don't know Vanna White. Excellent. So she has certain attributes that make her her, right? So if somebody starts using, I don't know if she's got a catchphrase or if it's her hair or whatever her persona is, and they start making money off of it without getting her permission, they're going to sue. So Vanna sued. Why? Because what's the bottom line here? Why do you think she sued? Not so much that they were using her likeness, but why?
Money.
Exactly. It was money. if they had paid her, she'd have no problem with it, right? Because it wasn't anything negative. It was just that she wasn't getting a piece. They were using something that she was famous. She's, the Wheel of Fortune. She goes like this. She touches the letters, and bam, that's her job, right? And she's known throughout. I thought, everybody knew her, but I guess not. So that's why. So when we talk about misappropriation, again, it's when we talk about civil cases, always think of money. Why? Because when people sue, it's so they can get money. So White versus Samsung is a case I usually test on, FYI, and it's about misappropriation. And the bottom line is you're suing because you're trying to get money. So that takes care of chapter 7. We're going to go on to now chapter 40. You're right. I do see why people, you guys had a lot of stuff for today. So now we're going to talk about intellectual property. Intellectual property is kind of fun. I think everything is fun. Although there's a chapter in this book that I do not think is fun, but we still have a long way to get to that. When we talk about trade secrets, I'm going to actually play with this thingy here, and I'm going to show you some things, and I want you to tell me what this is. If you saw this, hold on a minute. What is that?
It's a bunch of lines you drew.
No. Okay, let's say it was a company.
Louis Vuitton.
Thank you. Thank you. So, but it doesn't say Louis Vuitton, right? But you were able to know,
Just didn't do it.
right? Let's do another one. This is going to be a little bit easier. Ready? What's
Nike.
that?
Nike.
Yeah, Nike. That's right. What about this one? Hold on. This one, bear with me. Don't shut it out yet. I got to finish it first.
Apple.
Let me finish it. Let me have my moment. There we go.
Apple.
Thank you. Apple. Now, when am I selling apples here? Like, Macintosh apples?
No,
Nope.
you're referring to the brand.
Yeah, right. So if I wanted to sell, let's say it was very technologically advanced, and I actually was importing phones from a different country, and I wanted to slap that Apple sign on it. Can I do that and sell it?
No.
Why?
Not without paying them.
Not
they
without paying them, and it's not their product, right? Based on just the logos I showed you, the Nike, the Louis Vuitton, the Apple, what are those? I think I just gave it away in what I just said. What are those?
Logo.
Trademark.
They're logos. They're logos. When you see an item that has, I'm going to go back to this thingy here. Hold on, clear. When you see something that has, do you know what that is?
Reserved. Like a copyright kind of thing.
It's
Copyright.
registered trademark, right? What about if you see this?
That's copyrighted.
That's
Copyright.
copyright, right? So when you see those tiny little symbols on products, what does it mean?
It means that the
You
company.
can copy them and
Wait, I
they
think Joseph was talking. Hold on.
No, sorry.
That's okay.
Like that means the company has either patented them, copyrighted them, and went through the proper channels so that they own
That's
that
right.
piece of information or
That's
whatever.
right. It's a logo, right? When we talk about logos, we'll start with logos. There is a copyright on it, so other people can't just slap it on their product and sell it. And if they did that, what is that called?
Infringement.
It's infringement. It's copyright infringement, right? You're actually committing fraud because you're trying to sell a product that's not that particular product and making money off of it, right? So companies go through the USPTO, which is United States Trademark and Patent Organization, and they submit their artwork, they submit their logos, and they get that patented, they get that copyrighted, they get that trademark, depending on what it is. Why? Because then nobody can use it without contacting them, because they're going to be spending money. How much money does Apple spend on advertising, on marketing? a tremendous amount. How much money does Nike spend? Louis Vuitton spend? These companies are profitable because of the product that they offer, because of the marketing that they do, right? So they're spending a lot of money on their product. They spent and developed a following for their particular products. So they don't want just random people infringing upon that. And what happens is when somebody does use it, depending on whether or not they want to squish it right away or like sue them for whatever, they can get sued. I think I brought this example last year or whatever. A friend of mine, one of my friends, she's always trying to like embark on like new adventures or whatnot, and she started a like, you know, when you make paper and you put logos on it, what is that thing? It's like a paper company or something. And she had this name. I don't even remember what the name was. And she was like, yeah, I came up with this name. It sounded so familiar to me and it had like a nice ring to it. So she started advertising on Facebook and social media that her and her husband were starting this company and to contact them for all your printing needs. Everything great. Yeah, you know, go you, blah, blah, blah. A couple of weeks later, she gets an email and it was like, hi, so and so. I'm not going to tell you the names because this is being recorded and I don't want her to see this, right? So, hi, so and so. I hope you're doing well. Haven't seen you in a while. Just wanted you to know that the name of the company you're using is actually our company. So, we'd appreciate if you just stop using that name. You know, stop it. It's a something desist. Stop and desist or
Cease and desist.
huh?
Cease
Cease
and
and
desist.
Cease and desist, right? My brain is fried. I can't know. I don't know anything anymore. Cease and desist. Otherwise, we're going to have to take legal action, and we hope it really doesn't come to that. Hope you're well, you know. So she says to us, no wonder the name was so familiar, you know, when she kind of came up with it. So she didn't do her homework, right? She didn't do a Google search. A simple Google search will let you know if this company, this name that you're coming up with actually exists, right? If you go to the USPTO website and they have like a search, they have a search there. So you can search if the product that you want to actually patent already exists, if that name that you're trying to trademark already exists, if that item you want to copyright it already exists. Because if you go through the whole process and you submit it and it already exists, guess what? You're going to be denied that application. I've done applications for copyright. When I worked, you're talking about 15 years ago, when I worked for a company, a law firm in the city, and they had this logo that they had a artist create. And I went through the process with USPTO to actually get that trademarked, and it had colors and certain items. And I learned from it. I learned how to do it. I don't think it's that difficult. You just have to be kind of meticulous and do it. And I actually, for, you know, if you're from Staten Island, you know the restaurant known as the World? Enoteca Maria? It's the restaurant that had before
Yes,
COVID.
yes, it's so good.
Yes. So the owner, Joe, I knew him. I know him because I worked down the block, and I actually helped him with copywriting the phrase known as of the world, because that was something that he was doing, and you know, he's branding it out and he's making his own sauce and stuff like that. I remember when he had like all the logos now for the different the logo he's using now. But yeah, like that's to protect him from other people using that. Now, can somebody else in, you know, Kansas City come up with a restaurant and call it known as the World? They can. Is he protected? He could send them a letter, just like, you know, was done. But the question you then have to ask, that's part of the legal process, is the consumer likely to be confused between these two products? So if you're going to a restaurant in Kansas City that serves I don't know, hamburgers only, and known as the World on Staten Island is known for a different menu every single day, grandmother's cooking, is there a likelihood of confusion? Did you by mistake go to Kansas City when you really meant to go to the one on Staten Island?
No,
No, right?
no.
So there's no likelihood of confusion. So chances are there's not going to be, you can use the known as of the world in Kansas because there's not that likelihood of confusion. If I take that same Apple logo that I drew for you so well, and I want to have an accounting firm the restaurant is called Inoteca Maria. It's on Hyatt. If I stake that Apple logo and I put that on my accounting firm, because that's what I want to call it, Irine's famous Apple accounting firm. All right. And I use that same Apple logo. Is Apple going to sue me for using that logo?
Yeah.
Yes, most probably. Because it's not gonna have confusion.
There's no
I
confusion.
mean, yeah.
I mean, right?
Yeah. I
So
mean, they're probably never going to know.
they're never going
to
to know.
be
They're not
fair.
going to care. And even if I'm using an Apple that looks like that, you know, Apple, the company, is known for what? Their phones, their iPads, their electronic stuff. Nobody's going to think they're buying an Apple product at my accounting firm. Okay? So there's the difference. Now, when I actually go through my notes, okay, I'll now tell you the things that I want you to kind of know. When we talk about, there's something here that it's important. Okay. Okay, this I want you to write down exactly as I say it. Actually, I'm going to just put it in your chat. So when we talk about symbols, a symbol has to be distinctive and not a description of the item. I'm going to put this in the chat. So a symbol has to be distinctive and not a description of the item. That's how you can get it actually patented. But if I have an orchard and I grow apples and then I want to have my logo be the apples, like an apple, that might not actually go through because it's just a general description. It's not anything different. All the apple orchards they're going to want to have pictures of apples on their farm, right? Because they're selling apples. It's not something unique to that particular product. So a symbol has to be distinctive and not a description of the item. When we talk about service marks or certification mark or registration, it's those little symbols that I had kind of shown you. The T trademark, TM, service mark is SM, which copyright, those kinds of things. You can actually, let's say you go out and you get actually, let me give you this example. Whoever here has heard of the company Tupperware? All right, I saw some hands going up. What is Tupperware?
Plastic container.
Plastic containers, good. Now, can you get Tupperware in like Costco and ShopRite or anything like that?
Yeah, you can. Actually, it's a brand, but people started using it as a name for a plastic
Ding, 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 ding.
container.
And I don't know if you know that from my class last semester or you actually picked up on that from the reading. Tupperware is an actual brand. It's called Tupperware. There are items with the Tupperware logo on it. But people started using the words Tupperware on a regular basis to describe plastic containers with lids. And then that item actually diluted the Tupperware brand because everybody was referring to plastic containers. Hand me that Tupperware, right? I'll give you an example. And this is with my mother-in-law. My husband's ears are going to perk up because now I'm talking about his mom. So when I first met my mother-in-law, we were in the house together or something, and she's like, "Can you hand me a Kleenex?" And I said, "Kleenex?" And she's like, "Yeah." So I looked, I was like, "We don't have Kleenex. We had this other brand." The word Kleenex to her was a description of Simply tissues, right? Because when people say, "Give me a Kleenex," there's an actual brand called Kleenex. Somebody said with the Bounty paper towels, same thing, hand me a Bounty. I got Costco brand over here. I don't have Bounty, so you want my paper towels or not? It's an actual paper towel, right? Xerox is an actual company that made photocopies of things. But when people start saying, "Can you go Xerox that?" it dilutes the meaning of the actual company. And unless the company can try to safeguard that, oh, my mom calls any brand window cleaner Windex. Yeah, right? But it's not Windex. It could be Fabuloso. It could be something else. It could be the Walmart brand name. It could be any of those things, but everything, it's Windex, right? So it's the same thing. When you start calling everything by that particular, he doesn't like this. When you start calling everything by its particular name, it loses its identity. And so then companies have a hard time trying to sell their product because the consumers think everything is that particular product. Okay? All right, great. Let's move
That's
along.
it's like the opposite because you're giving like free publicity for the product.
It could be looked at this way, but when you actually now go buy the product, are you going to spend this much more to buy the actual Tupperware products? Are expensive. They're expensive, okay? But, or you're going to get something that is the same thing, but, or maybe looks exactly like it, but a lot cheaper. You're not going to actually spend the money on the Tupperware brand. Although I will say that my husband bought me this like Tupperware thing, actual brand Tupperware pressure cooker. And I have another pressure cooker. I have the Instant Pot. We're not getting it. I love all those products. I love kitchen gadgets. And that Tupperware thing, the one that goes in the microwave, I make rice like nobody's business. I've become a rice expert. So it's good for that. So I told him, I was like, at least we got our money's worth in making rice. So some products, their value, they might be more expensive, but they work better. So as an FYI, but yeah, let's see here what else we have. So that is, okay, so I told you that you can lose your trade symbol if it becomes generic. And that's pretty much all of the stuff that I want you to know about intellectual property, trade names, patents. Okay, we're going to move on to chapter 43. We're going right along. Accountant's legal liability. The only thing I really want you to know with an accountant's legal liability is you can be sued. Like, if you are an accountant, and I know a bunch of you are actually, accounting majors, how do you foresee yourself being sued in the future? If you want to raise your electronic hands and tell me that's...
Accidentally like giving the information out or something like that.
Say that again?
Like exposing that information accidentally on purpose.
Okay, so basically like you have private information that somehow got into, somebody else's hands. You can be sued for that, right? What else? How else can you be sued?
Forging the statements, let's say, or filing wrong stuff, and then it can be discovered later on.
Yep, filing wrong information, filing false information that somebody can rely on. So let's say you're hired to evaluate a business because the owner is going to sell that business, and you value the business at $100,000. So somebody buys it based on the fact that it makes revenue that's $100,000. After the new purchaser buys it, they realize that there was an error in the numbers and this business is only like $50,000 worth. Now, the new purchaser relied on your numbers. Can they sue you? Yeah, they can sue you. You can be sued for anything. Don't think that, everybody can be sued, I always say. Whether or not there's going to be recovery is going to be the question. So did that person justifiably rely on the information that you provided and made a determination based on information that cost them money? Yeah. Should you, then the flip side, well, should you have gotten your own accountant to verify that information? Yeah. So that's going to be your flip, right? So you always want to think about liability when it comes to the statements and the numbers and things like that. I have an accountant, right? I don't do my own taxes. And the reason for that is I want somebody that I can sue if I need to. He's a good guy. I hope I don't have to sue him, right? But if I give him the information, he files it incorrectly, I get hit with penalties or blah, 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 because he made a mistake. Am I going to pay for that? No. What do accountants always put? Smart accountants anyway. What do they put? Like the first page, like when they send you paperwork.
A contract.
Contract. What are they putting in the contract before they file your papers, before they actually file your taxes or whatever it is that you're giving them? What are they saying? What would you say?
Probably like limiting their liability.
How are they limiting the liability?
I don't know, stating that they're not liable for any penalties or anything like that.
Think more. If I'm your client, I'm a shady individual. I give you some stuff, but I keep out others. You're the accountant. What do you say? You don't know that I'm shady, but what would you say? to kind of protect yourself? All right, I'll tell you. You'll say that you are basing your paperwork, your taxes, based on the information I give you. So if I give you wrong information, you can't be held liable. Because if I'm withholding information, how are you supposed to know it? Right? So you always say as an accountant, and this is a life tip, that you are preparing these returns based on the information provided to you by your client. That way, if anything comes back, well, you didn't tell me. How am I supposed to know? Then you always make them review it. Well, you reviewed it. If I made an error, you should have caught it. Flip side is, well, why am I paying you then if I have to review everything, right? So it goes back and forth. But you always want to, in life, protect yourself as much as possible from potential lawsuits. That's how I go through life. Is this a potential lawsuit? That's how you live it, right? Because you don't want to be sued. And if you are sued, what is the likelihood of recovery? Okay. And that's really the only stuff I want you to know about accountants' liability. We're going to move right along to Chapter 8, which is negligence. And that's good. Look, we only have Chapter 8 and Chapter 47, so we're doing pretty good. Not too bad, right?
You made it seem so good. It took me
That's
2
why I'm
days.
here. So Chapter 8 is, again, more negligence and strict liability. Again, when we talk about, so let me talk about strict liability. There are certain things within torts, which is a negligence application, that if you do it, you're basically screwed, right? If you sell alcohol to a minor, there's no oh, I didn't know. There's no it was a fake ID. No, you sell alcohol to a minor, you're gonna get fined. Done. There's another thing. I'm gonna put it in the chat though, because I do not want to discuss that out loud because I have children here. Okay. Got it? That's also, once it's done, you know, there's really no I didn't know is not an excuse. Wrong ID, not an excuse. You do it, it's kind of like, you know, too bad for you. Okay? So those are the things that are strict liability, and they have a criminal component to it. So it's not based on negligence. It's not the intent, it's the activity itself. So that's just the strict liability. So now we talk about, again, regular negligence. And when we talk about negligence, it's those 5 elements that I talked about earlier: the duty, breach, actual cause, proximate cause, and damages. And now we're going to go into a little bit more detail about the duty and the reasonable person. And the reasonable person is who I mentioned to you a little while earlier. When we talk about duty, we talk about the reasonable person. And who is this reasonable person? Because you see a lot in cases or the court, they compare certain activities to the reasonable person. What would the reasonable person do? What do you think, if you had to give me a definition of the reasonable person, who do you think the reasonable person is?
A perfect person.
It is the perfect person. It is the person that makes no mistakes. It is the person that drives at 10 and 2. It is the person that always looks completely both sides before they cross the street. It is the person that does not speed. It is the person that knows all safety rules and does things the right way. So you're going to be pretty much compared to a perfect person. There are actually, and I need you to know this is a write it down moment, but I'm going to be talking about a lot of different things. So write down the important things. But when we talk about the reasonable person, there's actually classifications of the reasonable person. Okay. So I'm going to give you, I think there's like 5 of them. And I'm gonna talk about each one. So the reasonable person, the regular reasonable person, is always careful, prudent, and never negligent. So the reasonable person is always careful, prudent, and never negligent. What about if you have an incident that involves a minor? Okay? If you had somebody that was 12 years old and the 12-year-old was playing baseball in the backyard She hits the ball. She hits the ball with her bat, and it goes and it hits the neighbor's glass window. Who is the 12-year-old going to be compared with?
You.
Oh,
Say it again.
You.
Me?
12-year-old.
Another 12-year-old. When we talk about incidences that involve minors, we compare them with another minor, same age, but a perfect one. Would a perfect 12-year-old have been playing and hitting those baseballs that hard in the backyard, knowing there's neighbors all around? So when you compare to see if there's liability, when we talk about minors, we compare them to other minors. When it could be different is when that minor engages in an adult activity. So if a minor engages in an adult activity, they can then be compared to a perfect adult. So if a minor drives a car and hits another person, and this person is 11 years old or 12 years old, and you got to be like, at 16, 17, right, to drive, they're not going to be compared to an 11-year-old. They're going to be compared to that adult activity. If they commit murder, are they going to be compared to an 11-year-old? Maybe not. They might be compared to an adult who's engaging in that same activity.
Professor,
Yes.
would the parent have any fault in the case? Would they be
Absolutely.
blamed at all?
Yeah, they're gonna be. It depends on the situation. So for the baseball, they're gonna be blamed. They're gonna be the ones that have to pay, as well, because when you're suing somebody, you're not gonna sue the infant. You're gonna usually sue the parent as the guardian for the infant. So they all get
Right,
roped
right.
in, and
Right.
yeah, it's the parents that are ultimately gonna pay, but it's gonna be the kid that's on trial or the kid that's going to be in a hearing, and their actions are gonna be evaluated.
Professor.
Yes.
Sorry to
No,
interrupt you.
go ahead.
Question. As far as like being charged as a minor and being charged as an adult, whose discretion is that up? Like, is that up to the judge only?
It's going to be usually the judge, but also depends on the actual act itself. So they look for precedent, they look for cases that are similar to see whether or not, they look for prior bad acts, they look for a slew of things, but usually, let's say if it's a murder thing or like an assault or something like that, it's going to be up to the discretion of the judge. A lot of things are up to the discretion of the judge.
All right, thank you.
You're welcome. So we have the regular perfect person, we have the minor. The next one we're going to talk about as far as reasonable persons is when there's somebody under a disability. So let's say I'm crossing the street and I actually had injured my leg because I slipped and fell at my parents' house. So I can't walk and I have an injury. So the light turns in my favor. I start to walk. I don't make it to the other side in time. I get hit by a car. Worst week of my life, right? First slip and fall at my parents, then get hit by a car. I'm now suing the driver. Who am I going to be compared with, and who's he or she going to be compared with?
Wouldn't you be compared to a perfect disabled person?
Yes. Yes. Somebody with the same physical disability as I have. Somebody with the same physical disability. So when we talk about persons with physical disabilities, you are compared to somebody with the same physical disability. However, when you talk about persons with mental disability, and this is very unfortunate because I work a lot now with people with mental disabilities and that kind of area of the law, you get compared to a perfect person. That first standard we spoke about. So
Why
if
though?
somebody,
Why though? Why
the
is
law
it?
has not caught up with mental disability and mental illness. As a matter of fact, just it was just a couple of years ago, the statute for people with mental disabilities for the SCPA, it called them mentally retarded. That's how the statute referred to people who had mental disabilities, mentally retarded. That was just changed literally a few years ago. Just
Now,
changed.
Question:
So-
Do you think in like 10, 15 years, like we'll look back on these cases and some of these people will end up like being pardoned or having shorter
Yeah,
sentences?
yeah, absolutely.
Like,
So people, when if somebody's charged with a crime, like one of the things that there's a plea for is insanity, right? Or they'll try to plead out if the district attorney's office can see that this person is clearly intellectually disabled. But our community as a whole does not really understand or want to understand mental illness. So you have people on the street that are homeless, a lot of them, they probably suffer from mental illness. A lot of them do, but there's no way to actually like help them. It's just like, ask people, what did they do to, they did this on their own. They caused themselves to do that. And I'm not saying that that's not for every case, but people, for the sake of this discussion in this 100 level class, people who have mental disability are compared to persons who are perfect. Okay. The last one I'm going to talk about, because now we have regular, we have children, we have physical disability, we have mental disability, and now we're going to talk about when somebody has a superior skill or knowledge. So let's say you go to be operated on in a hospital and you are having injury, your left leg needed the surgery, but the doctor operated on your right leg. So the doctor is going to be sued now. Who is this doctor going to be compared to?
other perfect doctors.
Other perfect doctors. Yeah.
Same field, same
Same skill set, same
municipality.
entity. Yeah. What you also take into consideration is, let's say an ER doctor in the city, right? In New York City, an ER doctor in New York City versus an ER doctor in like, Timbuktu, or somewhere like where they have no people. Where is I don't Alaska. Alaska has no people, right? So you compare to an emergency. Thank you. You compare to an emergency doctor in Alaska. If that and who's got more of going on basically. So when you're also comparing people, you're also looking at their venue, where they practice, what their typical life is like, in order to have that more accurate description. Okay, so those are the 5 different standards. I do want you to know them. And that is, okay, hold on. That's that. Also, when we talk about negligence and somebody doing something wrong, I have this in my notes, so I'm going to just tell you. Somebody being voluntarily intoxicated is not an excuse to a negligent act. So you being voluntarily, not with it is not an excuse for any negligence action. Like, I didn't know, my mind wasn't there. Oh, you voluntarily were intoxicated or inebriated or whatever it was. Okay. So that is that. Let me just take a look at the syllabus real quick. Okay. Next case we're going to talk about is Ryan versus Freizen Han. Who wants to tell us about Ryan versus Freizen Han?
Sorry.
Okay, Lucas, you have your, Anna too?
Yeah.
Okay.
Sorry.
Go ahead.
No, I remember a little bit about it. There was a party. Sabrina got intoxicated and killed in an accident, and Ryan sued Fry for serving her alcohol.
It was the parents, right? Do you remember what happened? Do you remember the outcome or no? Okay. Lucas, do you remember anymore? Okay. Anybody else want to add anything to Ryan versus Freizen Han?
I think because it's a minor, so they were liable.
That's right. So what happened was Sabrina went to this party where they were serving alcohol. She got intoxicated. She drove. She got killed. her parents sued the host's parents. Now, there was a particular law in that state that said, hey, listen, it's kind of like on you. Like you drank, that's on you. You shouldn't have drank and drive. The problem with this case was that Sabrina was a minor. So as a minor, she shouldn't have been drinking in the first place. So that's why the host's parents were found liable, because adults don't control, or they don't have control over other adults. So like if an adult was at your house and they drank and they left and they got into a car accident, you're not going to be sued. There's some situations where you can be. But you are, as an adult, you're supposed to know what's happening with your children, with minors. So if they're engaging in this type of behavior, it's your responsibility as an adult to not have it happen, or to then take responsibility. So the parents of the host were actually found liable in that case, simply because it was a minor. Hold on, I dropped something and here it is. Okay. The next case I want you to know. La-di-da-di-da. Okay, so it's again about duty to act, and it's Soldano versus O'Daniels. I think that's a fun case. I like this one. All right, it's not really that fun. It's not like a happy, but who wants to tell us about Soldano versus O'Daniels?
Was it the incident in the bar
Yes, it was.
where the person in the bar they tried to go get help in the other bar, but they wouldn't. The owner of that other bar wouldn't let them use their phone.
That's right. Exactly. Absolutely right. So there was an incident happening at one location where somebody got shot and they were injured. So one person flees from the first location, goes across the street to another bar, and he's like, listen, can I use your phone to just call for help? And that person was like, no, I don't want to get involved. And that person ended up dying. And there was liability incurred on that person that prevented that phone call from happening. And the reason for that is the court said that, all right, you didn't create this peril, and you don't have to take an affirmative action to actually help, but there is a special relationship here because this was a bar, right? It was an open place for people to come in off the street. It was an invitee relationship, so people could come in. You giving them a phone to call for help is so minimal that you shouldn't. If you had done that, this person could have been saved. It's like nothing on your part. You're not calling. They just want to use your phone. So by actually not letting them do that, you've incurred liability. So it's not taking that affirmative step. It's just, hey, here's the phone. It's like not going to do anything for you to prevent that. Would it have been different if the person went from that first public location to a private location, somebody's home? Maybe, because a person's private home or their car, they're not expecting strangers to come to their house. So if that piece of fact was different, then maybe the case would have had a different outcome. Okay, good. Go, Tyrese.
Would that kind of relate to the the kid, what do they call him, Junior, that from the Bronx? You know what I'm talking about?
Oh yes, yes, yeah. Where they went into that store, right?
Yeah.
Yeah, that would definitely be in that situation, because they went into the store where the person who owned the store could have done X, Y, and Z.
Okay, that makes sense. Thank you.
Okay, so that is Soldano versus, okay. Next case I want to talk about is I love this case also. Love versus Hardee's Food Systems. Who wants to tell us about that? That's a fun case. And I usually test on something similar to this. So you should know this case. Love versus Hardee's Food System.
I know some about it, but I saw someone before me raising.
Okay, anybody? I didn't see that. Abu Kaber, is that you that raised your hand electronically?
Yeah, that's me.
Okay, go ahead.
So, in November 15 of 1995, Jason Love and his mother went to Hardee's restaurant There were at that time there was no customers between 3 and 4, but there were 2 or 3 workmen working the construction site. They didn't use the restroom at all, and when Jason went to use the bathroom, he slipped on water, and that caused an injury to his leg and his back, which had to do 2 back surgeries. And they sued Hardee's because of the injuries that caused to him. And at that time, the supervisor was unable to produce like the timestamp or the clock in time for the
Right.
maintenance worker,
Right.
nor nobody checked the bathroom, because the policy dictates if you're cleaning the table, you're supposed to clean the bathroom to check it. As well, they're supposed to check it every hour on the hour.
Excellent. Very good. Right. So what did this guy, did he recover anything? The guy that slipped?
He got, let me check my notes.
The number is not important if you remember if he recovered anything.
Is it
I
like
think he got like a fat check from them.
Yeah, he got $125,000. And this case is really very good. You did a great job with that. It's about slip and fall. It's a slip and fall accident. And you should know this, right? Because slip and falls happen all the time. When do you recover? When do you not recover? What's interesting about this case is that you're supposed to have the owner of the establishment was supposed to have people check the bathroom on a regular basis to make sure there's no water. So they clean the table, they clean the thing. And they had a log. And when it was actually time for the trial, they couldn't produce that log. They had that page missing, right? They also had somebody that left and didn't actually do what they were supposed to do. And it wasn't busy. And these facts are important. Why? Because if the owner does not have proper notice or did not have the ability to take the correct action, then maybe there's no recovery. So I'm going to give you an example. Let's say I'm walking in ShopRite and I slip and fall on a jar of sauce, red sauce, that somebody had spilled. Can I sue? Actually, no. Let me say that again. Can I recover money if I sue?
It depends.
It depends. Good answer. It depends. How long has that sauce been there? Did the owner of the store have notice that there was an incident there and then their employee failed to clean it up in a reasonable period of time? Just because something fell, a jar broke or water or something spilled, doesn't mean it has to be instantaneously cleaned up. There's a window, right? A reasonable period of time. So don't think that, oh, you see a jar, you slip and fall so you can make a nice recovery, get free groceries for life. That's not how it works, right? Because it depends on how long that product was on the floor. It depends on if the owner had notice. It depends on whether or not, number one, injury sustained. Did they have the opportunity to clean it up and fail to do so? Okay, that's why I called my parents about that slip and fall. Did they have notice? They got to clean that stuff up. So it's the same thing with stuff in grocery stores. And you will read about that stuff, in the Stand Out Advent sometimes. They have like the slip and falls and recoveries. It's all very fact specific. Okay, very good. This is actually, let me go back to the syllabus. Okay, I love you. Okay, res ipsa loquitur. I love that. If you want to seem cool in front of your friends and like throw out a Latin phrase, a legal Latin phrase, this is the phrase, because everybody wants to be cool and speak Latin, right? Res ipsa loquitur. And I'm going to put that in your notes. Okay. And this is actually a common phrase that lawyers will throw out randomly to seem cool, because that's our definition of cool. Throwing Latin phrases around. And what it means is the thing speaks for itself. The thing speaks for itself. Like when you see a particular incident or something happens, sometimes it's hard. No, that's not the secret attendance word. No, I'm just laughing because I thought it was funny. When you have an incident, it's sometimes you don't need all these facts, because the thing itself, it's there by virtue of it occurring. Maybe something has happened. So it's just a fun phrase, res ipsa loquitur. It means that the thing speaks for itself. I'm going to give the secret phrase. Let me just repeat this. You are not allowed to put the secret phrase in the chat. So when I say it, you are not allowed to put it in the chat. So I'm going to repeat it a couple of times. You have to write it down. Okay, I'm going to also write it down, February 8th, 2021. Okay. So the secret phrase for tonight is Simon finally got a haircut. Simon finally got a haircut. One more time. This is the secret phrase for attendance purposes for tonight. Simon finally got a haircut.
And that's true.
It is true. Thank you. That was that was Christopher. He's talking about his brother. So yes, he finally got a haircut. So that's the secret phrase for today. So don't forget, once you have 9, go away now. Once you have 9 of these phrases plus the first week that we have, then you can submit it. And so for February 8th, Simon finally got a haircut. That's how you'll get attendance for today. So we're going to move along. We're actually doing pretty good. It's almost 8 o'clock. We only have a lot of more stuff. Okay. So when we talk about, remember we talk about negligence and the 5 elements, and we talked about the duty, and we talked about breach of that duty, and then we talked about actual cause, and then we talk about proximate cause. So proximate cause is one of those really interesting legal concepts that you can spend weeks on in law school talking about. So when we talk about factual cause, that's easy. Factual cause is actual cause. What's the actual conduct that caused the harm? Proximate cause is really about foreseeability. Is it foreseeable? Was it foreseeable that X would happen as a result of whatever took place? So, oh, there's people here. Do we email it to you? Email it to me after you have 10. Oh, if you were here last week, yes, 9. Thank you. So the case of Palsgraf versus the Long Island Railroad is the case on proximate cause. This is a case I want you to know. This is the case that's actually taught in law schools all over the country to highlight, to explain the idea of proximate cause. I love this case. I think it's so ridiculous. It's just great. So who read Palsgraf versus Long Island Railroad that can tell us about it? Amar, you gonna? Okay, Lucas, tell us.
A plaintiff was standing on a railroad platform purchasing a ticket, and then like a train stopped. Like when a train stopped, 2 men ran for it to catch it. One of the men fell, and 2 railroad employees like tried to help him out. And then like in the process of that going on, a package containing like fireworks fell and the contents exploded, right?
Correct.
And
then what happened?
When some scales at the other end of the platform fell and struck a plaintiff.
Mrs. Palsgraf.
Yeah, right. And then the plaintiff sued.
Good. Excellent, excellent, excellent. So the ridiculousness of it, I'm not exaggerating, right? So you have a person, 2 people trying to get onto the train. All right, so imagine this. In real life, if you've taken the trains, right, pre-COVID, and they're all busy and there's a million things going on, and you're running to try to get onto the train, and these 2 guys are helping you on, these are train employees trying to help you get onto the train. You were holding a package because everybody carries dynamite with them, right? You drop your package of dynamite, it hits the railway, it explodes, it causes a scale on the other side across the platform to fall and hit a little old lady named Mrs. Palsgraf. If I was to give you the scenario of, and just end it at, somebody was trying to get onto the train and a package fell, would you have ever in your wildest dreams thought this scenario would play out?
Nobody think that there will be a firework in that package.
And
Or
fireworks
explode.
that explode and cause something on the other side to fall and hit somebody, right? So if you can't imagine it in your wildest dreams, then it's probably not within that context of proximate cause. So Mrs. Paulsgraf sued, but she lost. Why? Because it wasn't foreseeable that those injuries would occur. No way, right? There's no way that you would think.
There was no negligence.
Yeah, no, there was no negligence. The trained people, they didn't do anything wrong. Like, there is no way for you to think that that would happen. So proximate cause is the foreseeability factor, right? So is it likely to happen? Is it likely not to happen if that particular incident did not take place? So if I am driving, now let's take it back to reality. If I'm driving and I rear end someone, is it foreseeable that they're going to get whiplash? That's foreseeable. Is it foreseeable that I hit somebody and they're carrying fireworks and the fireworks explode and the car down the block, those people get injuries? Maybe not so much. Maybe not so much, right? So proximate cause is all about foreseeability. Do you have any questions on proximate cause? All right, we're going to move on to now defenses to negligence. Remember last time we talked about defenses to criminal activity? So now we talk about defenses to these negligence actions that we just spoke about. When we talk about the defenses, use what you kind of had last time, which may not always be helpful, but think along those lines. If let me give you a case. Let's say you were slip and fall, right? What's this? If I slipped and fell and now I'm suing you, what would your defenses be? You're the employer. You're the ones that own the store with the jar of sauce.
We had up a spill sign.
We had a spill sign, right? So you knew about it. You were noticed of it. Good. Anything else?
Maybe it spilled 2 minutes before, so we
Right.
weren't even aware of it. And
Exactly.
Then,
yeah. So there was, you actually, the first thing you said was that you had that sign, the spill sign. That's contributory negligence on my part because I failed to exercise reasonable care. So if I contributed to the accident because I wasn't paying attention and I slipped and fell, that's contributory negligence, right? The other thing is assumption of the risk. And this is something that it's when you go skydiving or when you engage in a dangerous activity, what do you have to sign? Has anybody here gone skydiving? That's right, waiver. You got to sign a waiver. You're basically waiving. If you die, if you get injured, if you get maimed, you're not going to hold them company. No, you're not going to hold them liable, right? So you are waiving any and all rights that you have. The chute doesn't open, can't sue us. Well, you're dead anyway, but your family can't sue us, right? So when you engage in dangerous behavior, you are assuming that risk. Those people that go and fight with like crocodiles and alligators, I mean, you're not going to sue the alligator, right? But those people that engage in extreme sports can't sue. Why? You signed a waiver. You're assuming that risk. Okay. So that's also a negligence. This is, I'm gonna kind of just tell you this as an FYI. There's also some states have these theories. It's called comparative negligence. So you will get an amount, a portion to you based on how much fault you had in causing an accident. So let's say there was a street and there was cars whizzing by and I was trying to get to the other side of the street and it wasn't my light. I just decided to try to make it. So now I'm going across the street and I get hit by a car. that car was going in excess of the speed limit, but I also was going in an area I was crossing when I wasn't supposed to. So there, I might, the jury might find for me like and award $100,000, but if they find that I was 50% negligent, how much am I going to get? Half, 50,000. What if they find that I was 75% negligent?
75%. Okay.
No,
No,
would you not get nothing?
25%.
I would
Yeah.
get 25,000. If I was found 75% negligent, I would only get 25,000. There are some states where if the negligence was more than 50%, you don't recover anything.
Yeah, that's what I was about to say. I was gonna say, wouldn't you get nothing?
Yeah,
'Cause it was your
you didn't
fault.
meet that burden. Exactly. It's your fault. So depending on where you're at, that's going to be kind of what happens. So those are the defenses to negligence actions. The next case I want you to, we're going to go together, is Palumbo versus Newkirk. And then we just have property, and then we're done for the night. So Palumbo versus Newkirk. Who wants to tell us about that? Anyone? I know it's a lot for today, right? There's a lot of material.
Well, I know it, but not in too much details. So.
Yeah. All right. Palumbo, I will be nice because it's my first day like teaching, and since we started the syllabus, so I will tell you about this case. But again, for next week, starting next week, if nobody volunteers, I'm not going to tell you what the case is about. So this is a. Do you want to say it, Amar? Do you know it?
I know. I said I know. It's just not too much details.
That's okay. Go ahead. Go ahead.
I know it's about
fill it in.
milkman who was delivering the mail, and then there's the dog of the owner. And then the dog bitten him, and then he was suing the owner of the dog for the injuries he sustained. So, and then I think he won the case.
I don't
Sure.
think he won on this one. He didn't win in this case because and this is what you get out of this case. When you have a pet and the pet like bites somebody, there's always you get a free bite essentially. So the question that's asked is, does this dog or does this animal have a propensity for danger, or propensity for biting, or propensity to cause harm? So this was the first time that dog did that in this particular case. So there was no liability on the owner because there was no way for them to know that the dog would bite the male person. If, however, the dog bites another individual and then they sued, they would have been able to recover because now the owners know that this dog is a dangerous dog and that there has a history of these things. Okay, so that's that case. And that kind of concludes Chapter 8, which is all about negligence. So we're going to go with now property. And property is also fun. Let me just see here how much stuff, because we also next week we also talk about property. Let me just see here. Actually, I could potentially leave off with chapter 47 because next week we only have 3 chapters, and next week we can talk about all the stuff that's property. So that way it's going to be property about land, and then property that's transferred over, and then property, wills and trusts. And then after that, it's actually first exam. And it's actually perfect because as you can hear, my son is going crazy. So do you want to do that? We can just leave off here and then we'll do everything the week after next, Professor. Okay, thank you.
That's fine.
Yeah, so next week we'll start with chapter 47. I'm going to put a note here for myself. Chapter 47. And then it'll be 47, 48, 49, and 50, which is not too bad. Today we went through chapter 7, 40, 43, and 8, and there was a lot of stuff in there. So, okay. So next week we'll pick up on chapter 47, and next week will all be property. After next week, whatever that, we actually have our first exam, but somebody pointed out that it's the week after. Let me take a look at the syllabus.
The syllabus is next time is February 22. Is there
wow, that's right, because you know what? That's right, because next week I think there's a holiday. That's right, President's Day. So I'm not going to see you next week. Have a wonderful, safe days off. I will see you on February 22nd. We'll go over 47, 48, 49, and 50. The week after that will be our first exam. It's going to go by quick. Next exam is March 1st. That's correct. Does anybody have any questions on the material that we covered so far?
I have a question, Professor.
Sure, go ahead.
So to backtrack, the book mentioned about the Good Samaritan Act.
Yes.
Now, my question is, if you help someone who did not ask and did not want help, for example, that famous scene from The Incredibles, where Mr. Incredible jumped in the building to help that person whose intention was to suicide and sued him. Can that
Wait,
apply
are we
to
talking
today?
about Incredibles the cartoon?
Yes.
I don't remember that part. Yes. So the Good Samaritan laws are meant to protect people who are trying to help others. Can they be sued if somebody's trying to do what you just said?
Correct. If someone wanted to inflict harm and or didn't ask for help, can that person still sue?
I think everybody can sue. You can always sue. The question is, can they recover? I don't know if they can recover, because if we just, again, I don't know if they'd be able to cover, because we're going to go look at those. Remember the 5 elements of negligence?
Yeah.
Were there damages incurred? The damages to that person would be like, hey, I wanted to lose life and I didn't. But they can try again, I guess, right? So it's not like they lost out on that opportunity. Does that make sense? I don't think the person who were trying to do the Good Samaritan Act, I don't think they would be found liable for preventing that person from taking on their, the actions that they intended. Because if that was to happen and this person would be found liable, then it would prevent other people from also helping others when you don't know at that point in time whether or not this person wants help or not. So, and sometimes you need to act in a split second, in a split moment, right?
Okay.
So I don't think that person would be found liable. That's just my opinion.
Okay. I have a second question.
Sure.
If a company or a business sells like their franchise or product to another company, does the new owner have the patent on that product, or is it still public domain?
Can you give me a more specific example? A franchisee.
For example, when George Lucas sold the Star Wars franchise to Disney, now does
Mhm.
Disney have like the patent over Star Wars for that
Yeah.
specific amount of
Yeah.
years?
When they sell it, they can use those products, so they can do whatever they want with it, and it would be in their contractual negotiation as far as how much authority they have. But when you sell your product, you're also selling the patents and the intellectual property associated, usually, unless that's part of the contractual negotiations and you're holding that up.
So after that, let's say X amount of years, the patent become public domain again, correct?
Usually, I know that happens with drugs. I don't know if it happens with intellectual property like that, because I know that people die and their music is still patented and it's still actually like copyrighted, so their heirs actually still receive money from certain music that, lyrics. So I don't know what the time limit is. I don't know if it's indefinite, if it's intellectual property. That I don't know, actually.
Okay.
I was going to say something else. You sparked a thought, but then it went away.
Do
Yeah, I
all
don't know.
patents have the same like expiration, or is it
No,
different?
that's what it was. Drugs, right? So drugs, pharmaceutical drugs, they have a certain period of time where they're patented by their, creators or the people that came up with it. And then after a while, then it goes on the open market, and then like generic companies can make it. So then I know with pharmaceuticals, it's a certain period of time. I don't know if intellectual property is the same. I don't think it's the same, only because like Coca-Cola, for example, their formula has been secret for ever, right? I don't think that's going to go away because that's instrumental to their business. But maybe pharmaceuticals, because it's public good and so it's health, so there might be different laws that apply to it, but I don't think there is a timeline or a limit on intellectual property.
Okay.
Any other questions?
No, I'm good. Thank you.
You're welcome. Anybody
Yeah.
else?
I have one actually. The third element of the defamation, I honestly didn't really understand it. The failing to ascertain the falsity of the statement.
Yeah, it's basically if you're spreading rumors and you know that they're false. So when you're saying something, like if I'm talking about somebody, if I know that it's false and I'm spreading it, I could certainly be held liable. So it's really for like news organizations, and especially for people that are high profile. If you're going to spread a rumor about a politician or an actor or an actress that could really damage their reputation, the fact that you didn't verify whether or not that information was correct, you could be held liable because you didn't do your due diligence and at least look into whether or not that information was correct. Now, like, do you guys know what, like, those gossip magazines, the National Enquirer and things like that? All that stuff that they publish is like baloney, right? So are they actually getting, are they being sued for all this stuff? I don't know. I think there might be a different level for these types of magazines because like nobody believes anything that they read in. So it's that. I know people are like putting things in the chat about the goat. I don't know. MJ is the goat. I don't know what that means. So they're not animals. So I don't know what you people doing. So any other questions?
Yeah, I have one quick question. So
Sure.
we were talking about copywriting. It kind of brought something to my mind. I wanted to ask, could you copyright an idea?
You can patent an idea. Absolutely.
What you mean by that?
So if it's an idea that you have, you can, depending on the idea. Now, if you have an idea, I don't want you to say it. Oh, thank you. Greatest of all time. Okay. If you have an idea, like certain products are new and innovative, they have to be patented in order to make money. So if you have an idea, there's something called the poor man's patent. I'm going to tell you about that. Number one, thank you for clarifying the GOAT. It's not an animal, it's an acronym. I appreciate that. I'm going to go back to now the poor man's patent. If you have a great idea, you need to be able to show that you are the first in time to use it, to have that idea. That's how you get the credit for it. But to actually go through the patent process, it could be long and expensive. You need lawyers and sometimes like that. So whatever your idea is, write as much detail as possible about it. Put it in a sealed envelope. Mail it to yourself. And when it comes back to you, it's going to have a seal. It's going to have a post date on it of when you did it. Do not open that letter. That shows that that's when you had that idea. But now it's all about what steps did you take to have this idea? And if somebody else has that idea after you, did you share that? Did you give it to them? But it's a way until you kind of are able to patent it. I could have a brilliant idea about something, but is it an idea that's going to be shared with the world? Is it something that I'm going to use to like make money, like Post-its? Post-its are a great idea. Somebody thought of that at some point in time. Now that's a company, although you can get other papers that are, stick that have that adhesive to it. So it's probably, we call it Post-its, but they're not. They could be like a generic brand, but things of that sort. So depending on that was the long answer. The short answer, depending on your idea, you can patent it, trademark it, copyright it. It depends on the nature of the idea itself.
Okay, cool. Thanks.
You're welcome. Anybody else? Going once.
One last question.
Sure.
So I know you say the important stuff in the lecture because the paragraphs are really long.
Yes.
So let's say the paragraph is long. You mentioned one thing, two things from it. Do we have to study all of it or whatever you just?
Whatever I say.
Okay.
Whatever I say.
Thank you.
You're welcome. Anybody else? Going once? Going twice? Okay. After this thing is over, I'm going to do like I did last week. I'm going to post it to YouTube, and then I'll put it on Blackboard so you'll get notice of it. Okay? So I will see you guys all in 2 weeks. Have a great night.
Thank you. Good night.
Good night, everyone.
Bye.
Good night.